All right.
Hello, everyone. Welcome to our next webinar in the series, Implications of COVID-19, sponsored by AXA in collaboration with Cervantes Chat Prints. Today we have a special guest, Adam Czerwinski from Sidebar Insurance. So today we're going to talk about ensure your insurance covers your future. We just finally figured out how to be accustomed to all the restrictions and the new normal, and then we got Restore Illinois with the phases. So as we all know, today is an exciting day in Illinois. We hit phase 3, but some people are not really clear on the interpretation. We also have city phases, municipality interpretations, along with the Illinois phases. So it seems that there might be a need for clarification as to who's on first, and next, there's the prevalent issue of disputes. Disputes among the homeowners and the board and the management regarding dissatisfaction with the decisions that are being made. So today we hope to clarify and interpret the implementation of phases 3 and 4 and provide options for dispute resolution. The final portion of our presentation today will provide time for your questions for our panelists, both COVID related and just in general. And as always, please submit your questions as we go along, and I will make every effort to ensure that they are answered by the panelists. So once again, let me introduce, we have, I was trying to do it in order. Okay, we have Adam Czerwinski from Sidebar Insurance Solutions, Bob Prince, attorney with Chat Prints, Cervantes Chat Prints.
Thank you for the branding.
Also an attorney with CCP. How's that? Okay, so now I'm going to turn it over to Bill.
Okay, thanks, Bets. As you just had pointed out, we are in phase 3, so I'm going to bring that chart up so we can remind ourselves of what phase 3 is. Give me a second here. And here it is. So phase 3, certain businesses that weren't open before are starting to open up. Gatherings of 10 people or fewer are allowed. Face coverings and social distancing are still the norm. And as you can see from the chart, we're in the middle. We're not near a vaccine, so a lot of the stuff is still tamped down. As far as associations go, I would say that number of people, 10, is kind of a magic number, because the hot topic now that we're getting into the 80-degree weather, are particularly the associations that have swimming pools or common areas that people like to gather in. I think even prior to this, if you're walking around the pond in your association, or if you had walkways, that was fine. I think up until phase 3, the rule was if you came in contact with someone, you'd put a face mask on. But the pools are the big thing, and I'd have to say, and I'm sure Bob's going to probably nod his head, I'm surprised at how contentious an issue it is becoming. I've never had as many inquiries about pools in general as I have in my entire career doing association law. So what's happening now is, I guess we're getting it from both ends. We're getting boards who are resistant to open it, but they're getting a lot of pressure from homeowners saying, hey, we paid for it, we want it open. And then we've got some boards that are on their own looking to try and open their pools. And so with this phase 3, as you can see, gatherings of 10 or few people, that's not real conducive to a pool opening up, not to mention the issue of sanitizing the facilities like the changing rooms or the bathrooms. So there are some useful other documents that are out there, and I'm going to flip to this one. Geez, I thought I had it up. If everyone could just remain patient for a second while I pop this other one open. Here we go, health and fitness. I'm going to pop this one open, and this here, as you can see, this is from the Illinois Department of Commerce. Betsy had found some of this stuff here. If you go right over to 4, you can see that saunas, hot tubs, pools are closed. so obviously your public pools and things like that, your health clubs and all that. But the general consensus here is when you see that, if you want any guidance as to what you should be doing as an association, that kind of tells you right there. This has all the other phases too. Classes of 10 or less. So again, if you got an exercise room, it's really hard to conceive of controlling that 10 or less. I suppose you could on an exercise room, say, you know, to the extent that there's 10 people, no other people can come. But on the hot topic of pools, saunas, and things like that, right now, those are still to be closed under this. So give me a second here. I'm having an issue with my sharing of the screens here.
You know, Bill, since we're having issues putting it up on the screen, maybe we could repeat, if you could repeat for everyone, the site where they can go to find this. No, it's the Illinois Department of Commerce, correct?
Correct.
And it's the business toolkit, I believe.
It is. It is. I'm having an issue with my Adobe for some reason here. Let me end my Adobe session here.
It's really nice because there are also several, I mean, a myriad of posters, 8.5 by 11 size posters that you can download that some people may want to put up in their lobby or, you know, the entrances or whatever. It's very handy, I think. It was nice of them to put that together for us.
Yeah, I think I can bring that up here. Give me a second here if I can get that up. Yeah, this here is what you're talking about, which is the Phase 3 business tool kit. Got all the different, it's got that one we were just looking at, which is the third one into the right there. But there's also other ones that, like Betsy says, you know, you can post in your common areas, around any of the common facilities, and it kind of gives you, and then again, it's giving you guidance. So basically, that's where we are with this. And I think this is a great time to start turning it over to Adam in terms of some of the issues in, you know, you're trying to fight what's out there. Obviously, we still have the CDC guidance. That is not necessarily law. In terms of what we're following Governor Pritzker and Mayor Lightfoot's edicts that are coming out, their executive orders that are specifically telling us what to do. But now that we're starting to get to the point where people are trying to open things, I think a lot of associations are faced with making hard decisions. So, Adam, have you been getting calls from any of your association clients in coverage as to, if we do this, what's going to happen?
Yeah, so thanks for the invite, everybody. Adam Czerwinski here. Just want to quickly say to that point, I think that the fact that you're having this conversation is really important, because I think a lot of associations aren't even kind of taking those steps through this. So the answer would be no, we're not having a ton of questions in that regard, just because I don't think a lot of associations are kind of handling it with as much nuance as this conversation is going to.
Sure.
There's several layers I think associations should be concerned about with regards to the reopen, or at least discussing amongst themselves, given the current kind of flux and the current uncertainty. Because housing associations are living in this kind of gray space between strictly commercial and strictly personal, right? It's a shared experience where it's considered personal property, but it's governed by commercial contracts. It's a corporation, but people live there and own their own units. And so there is a lot of hybrid, because of that, there's a lot of hybrid evaluation that needs to be done and consideration. How our business is going to be treated and how our personal home is going to be treated. And that inconsistency or that conflict, because usually there's a very bright line rule, is leading to a lot of uncertainty, and people are overlooking some, I think, perils that they may be facing.
Yeah, and I think, again, I think Bob's going to agree with me. Today, you know, May 29th, pools should not be open, right?
That would be my reflection, my reflective answer, and there's a couple of reasons for that, because I don't think people just should kind of just willy-nilly say yes or no. From an insurance standpoint, which is where the angle I come from, there's a couple things that businesses need to kind of realize from a perspective of exposure and liability for both the host association and the board. So for the first level defense would likely be a general liability policy should someone say they contract COVID from a general space like a gym or a pool or wherever it might be on the premises. And there's a couple problems with that, because built into most kind of commercial general liability policies or built into most commercial policies, period, is an exclusion for risks caused by bacteria, mold, or infection. And so if it's an infection, and now does that exclusion apply to this? You know, can that be passed along? Can they prove it, right? So all of these uncertainties, and there are cases already pending against cruise ships and different entities that are already working their way through from those events that happened early in the pandemic where people were exposed on ships and different locations. So those have already started. And then the question becomes, does the insurance respond? And I think the answer to that question we have right now is I don't know, because we haven't seen it. We haven't seen the end result. And then, you know, as Bill and I have talked about before, do you want to be the first to figure it out? And do you want to find out if your insurance is really going to cover it? Sometimes it's better to ask permission than beg forgiveness.
Right.
And so something to keep in mind. So that's one level. I would say from a general perspective, if the general liability doesn't engage, because of that. There's also exclusions in most general liability policies or commercial policies altogether for actions that have taken in contra to government municipality order. So if, you know, they put that a lot of times in contracts because they, or in the insurance because they don't want to cover the restaurant that has a health order issue and operates in defiance of that. It's a risk they're not concerned with. But can it be used then to have businesses who are, and particularly in this case, associations who have ignored government recommendations and directives, like on that poster, which technically is for the health and fitness industry, right? But can be applied to health and fitness centers in association areas. So we have to be kind of conscious
And the
of that.
executive order is going to be one of those categories that you just spoke of, right? I mean, that's the governor saying, hey, look, this is what we've got to do right now. That has the force of law. So in terms of an insurance policy, that's going to be an issue for you.
It could be, right? Exactly. A lot of these, and what happens with insurance policies is they're written in such a way and they create conflict that allows sometimes insurance companies to do a cost-benefit analysis. If it's a big enough loss, if someone drowns in a pool, if someone suffers a significant injury or dies of a COVID infection, and that exposure is massive, and they can save money by fighting it and paying those expenses as opposed to paying the actual loss, they may take that risk. And then you're stuck with declaration actions and you're stuck with reservations of rights and places that put you into an uncomfortable situation. And then to the second point, I think I started on earlier, as directors and officers, do you then expose your directors and officers' decision? Like, is that policy in play? And they'll have the same level of exclusions, the same type of exclusions that may apply to the general liability policy. Was the decision made in dereliction or in direct contravention of the municipal order? You know, were they doing things outside of that purview? And now you have a question of whether that fallback directors and officers coverage becomes invalidated. Now you have to refer to each of your policies. There's a lot of people on this call. I think we see 49 down at the bottom. Each of your associations may have a different policy form. But the problem is, are you going to go through, read it, and then be the determiner and be sure about how that's ultimately going to work out? The comfort level, it would push me towards saying, let's just hold off and be prudent at this time, would be my recommendation. But you know, you guys are all kind of there. So those are a couple things to keep in mind.
I'm going to interject here because we're getting a lot of questions and I don't want, while we're on the topic.
We knew this would happen.
Another interpretation is this 10 groups of 10, okay? All right, so whether it's at the pool, in the pool, by the pool, walking around the area, whatever, is this interpreted legally as 10 total? Or you could have several groups as long as each group has no more than 10.
So I saw something on this morning that a news outlet reported that Governor Pritzker stated that the 10 requirement was mere suggestion, was guidance and not required. I mean, his order doesn't say it's guidance, it says it's required. So I actually have a number of clients who are talking about this and related to their amenities. And whether or not they could have more than 10 people in perhaps a very large room if they are clustered off from each other, or more than 10 people at a pool if they are clustered off of each other. My reading of the executive order says gatherings of 10 or more are prohibited. So I would equate it to this. Right now, I think all of us would expect you cannot have a wedding with 100 people, even if that's 10 tables of 10 people each. You're not going to be able to have that wedding of 100 people right now, even if you've segmented them off into 10 tables. So I expect that's how it would be interpreted. How it's going to be enforced, I have no idea. I can tell you quite quite literally that I've seen people drive by a large group of people, that were outside, that were way more than 10 people, and nothing happened to them. And police officers do that in large part because they're trying to be reasonable with it, I'm sure. But there is always that chance of you being the test case of, hey, you have more than 10 people here and you have the wrong officer on the wrong day who will then cite you for perhaps violating the order. Now, the guidance, I did hear some people talk with representatives as well who said that it is groups of 10, not 10 total. I'm assuming that they're talking about in defined spaces versus non-defined spaces. So like if it's a room or a building in which there cannot, it is in a building, it can't be segmented any less than that. If that room, 10 people in it. When it's at a state park, guess what? It is hard to divide that up into 10, only 10 small spots. So I think that's a little bit different. That's what I keep getting put back to me is, well, state parks allow 10 people, more than 10 people in groups of 10. But I think that's a very different thing than an occupancy of perhaps one room. And I mean, that's the one thing we're lacking on the pool issue is guidance. We have no guidance right now from any governmental entity about what to do and how to properly protect people if we are opening our facilities. So if we don't know what occupancy should be in a pool, it's difficult to be able to tell people and our clients to open their pool, because what it sounds like is you potentially could be going towards liability. And that's what we want to avoid, is going towards liability if we can. So, the conservative approach to the actual restriction, not saying if you are a conservative with a big C, that's what you believe in. Conservative approach would be that you should wait and see. Wait till we hear something from a governmental entity saying that we can do this. Because I look at all the park districts are closed. I look at, and a majority of them are closed for the season, the whole year. They've closed it. Businesses are closed. And there's economics that come to that as well. If they open their park, they have to keep it operational, and they don't want to spend all that money and not use it. And eventually the economies of scale make it so that they won't make enough or won't be able to absorb the uptick from the startup costs, but they are closed. We do have the Department of Public Health's director at one point saying, that it's possible that this could be spread through water and pool, whereas the CDC said it may not be able to. So we have this conflict of information that what it does for an attorney, it makes you feel uncomfortable if we are going to do anything but the most conservative option. And that is what we don't want to do, is get our clients in trouble, and we don't want them to get themselves in trouble.
And if you recall, a couple weeks back, I had thrown up that example on the screen from the state of Florida. Their equivalent of the Department of Professional Regulation, they actually did do that. They said, hey, for pools, 6 feet spacing, blah, and they had all these other things. I hesitated with detail because it is not Illinois. I don't want people looking at it. I don't want people relying on it. The non-committal of Illinois to speak to it, like Bob said, makes us feel uncomfortable. That said, it's not hard. It's not hard as an attorney to say, don't open the pool, because we just don't have the guidance. We're only in phase 3. I just think there's too much out there. And, as Adam pointed out, there's that is my concern, the risk of not having coverage. We were speaking yesterday, kind of preparing for today, and Adam gave us a really great example of how insurance, the claim process kind of works. You pay the premiums, you get this coverage, but then when you make the claim, there's this process that the insurer goes through. And Adam, kind of give us that example. You were talking about the drive-through at McDonald's. You get the meal, and you think you're going to get the bag, but they're like, wait, hold on a second.
Yeah, it's really unfortunate. So insurance it's a long written contract, and it does allow for interpretation in a lot of ways. There's lots for precedent in court call cases to kind of dictate how they're going to handle it, and also allows, as I mentioned earlier, some economic decisions. And a lot of times I talk to my clients about insurance, and insurance is like going to McDonald's, ordering a cheeseburger, getting to the end, paying for it, and then they say, wait a minute, you wanted to eat that. We've got to check the rules and the requirements on the policy to see whether this situation allows you to eat the burger. It is a frustrating situation to be in, but that's how insurance works. Insurance is made for specific perils, for specific events, to cover against sudden and unexpected losses. that that can be underwritten for, and where the law of large numbers will bear out a profitable business that would insure you against that risk, but at the same time make money for the insurance company so that they can operate and have employees and have a future. And so otherwise they would just become insolvent. So a lot of these insurance issues that we're tackling during COVID are things that, you know, we're actually in 2002, a lot of the changes we're seeing with these exclusions with bacteria and infections came just in 2002 with the Ebola epidemic that had come out. That was the genesis of a lot of these exclusions. So these are things that are insurance companies are going to try and extend, I think, is my expectation. That's the fear that people have been coming back to us, particularly on business interruption claims. You may hear or see a lot about those. They may not necessarily apply to the housing associations we're discussing today, but these are the applications of those exclusions. And I have a feeling they're going to try and do the same to avoid liability and exposure. They don't make money by handing out money for claims. They make sure it falls underneath their requirements.
And
I think what you said, I think what you were trying to say is insurance companies are in the business of denying claims. I think that's exactly what you were trying to say.
No, I wouldn't say that, because there are lots of times insurance will step up. It just has to be within the framework of the contract. Like, I don't want people to sit there and go, oh, insurance is a big scam. It's not. It's there for you when the things that they can kind of calculate for, when lightning strikes and planes hit or fire strikes, it's there for those things. Things like pandemics and floods and other kind of mass casualties, they're just not able and equipped to sell you a policy for $1,500 that gives you $3 million in coverage. There just isn't that exchange is not economically viable unless they limit what it applies to.
And I can tell you just from an insurance perspective, because Bob and I, we obviously that crosses the paths of where we do our work. You know, until there's the loss, and then if someone sues, then the insurer. I mean, you'd be amazed at the conversations that go on behind the scenes with the underwriters, and they're looking at that complaint and they are parsing it. And really, the ultimate one of the ultimate factors is how those complaints are worded by the attorneys who draft them. You know, you could say, hey, what if this and this and this happened? It's, oh, well, your insurance would likely cover it. That complaint gets drafted a certain way, and certain allegations are made or certain ones are left out, and the insurer goes, you know, you look at this paragraph here, the complaint says this, it says this is what is alleged, you don't have coverage. And then you get into this decision about, okay, they're going to deny coverage, and you have what's called a deck action. I think you might have mentioned it a little earlier. That's where the insurer, either on their own, is going to say, look, we're going to bring suit to declare we don't have to cover you, or based on a denial letter, the insured, here the association says, we're going to have to file suit because you should be covering it. So now, in addition to the issue you have of where you thought you were insured, you're fighting with your insurer to get them to cover it. So it can be a very interesting, sticky wicket when it comes to these matters. And the part I'm talking about, which is how the attorney drafts the complaint, you as the insured don't have control over that. You know, and it's interesting because I've had attorneys who file these things and they find out the insurance isn't covered. They go, well, I could, you know, because a lot of them have their mindset on getting something from the insurance company. And I've had an attorney say, well, I could just redraft the complaint to change that. And I'm like, well, you have a duty to draft a truthful complaint. So if there's something truthful you can say that you didn't, or something like that, that's your decision. But to come to me, the association attorney, and say, hey, you know, if we fix it this way, maybe we can get the insurance company involved. I can't be a part of that discussion because that is not necessarily a truthful allegation that as attorneys, we have to keep in mind. And I want to point out to the audience, just so people know, Adam is not only in the insurance industry, Adam is an attorney. So he has a very interesting perspective on the things he speaks of. So, you know, like I say, when we talk about how the complaint is worded and the allegations being made, it matters. And the insurance company is going to look at that. I mean, I've seen, you know, when I think about insurance law, which when you know, with the association law, Bob, are we at 100 decided cases in Illinois yet?
I'm sure. I'm probably 100, but not 500.
Right. Now you get to insurance and you do a search online, your computer's going to break. And you know, some of them are very interesting and some of them are, you know, okay, you know, you need a little help reading the case. I've seen insurance companies fight over $4,200. You know why? Because there wasn't a case decided on that issue. And that $4,200 one could affect the $4.2 million one down the road. So they will fight over that. I had a relative who got into a car accident. One car was going one way, one was going the other in a snowstorm. They met at the center line and they did this. the companies sued over $4,200 because they were like, hey, your policy, my policy. Insurance companies need precedent, and that's what case law gives them. So if we do a case search and we can't find an answer, fasten your seatbelts because it's going to get interesting.
I would say, like, when you're talking about how you draft it, like, there's exclusions, as you mentioned, for communicable diseases in almost every policy. I expect in every policy. I shouldn't say almost. Every policy probably has it. And if the complainant drafts the complaint that says, I'm suing you for the damages associated with the communicable disease that I contracted at the property, there's going to be a reservation of rights and likely no coverage. If they craft it as, you shouldn't have opened the pool that allowed me to get harmed, and leave it blank of what the harm is other than to say it's harm, there probably is coverage at that point, or a duty to defend, because at that point it falls into a decision made by the board as opposed to the communicable disease allegation being thrown up there. Now at the end, the fact that it's communicable disease is coming out, and there will be a reservation of rights eventually given on it. But until that point, at least there would be coverage until that perhaps maybe could resolve a case. So it does happen in the real world right now. It will happen in the event those things, people do contract viruses at our pools.
And just one more thing, if I could inject. So one of the other issues with insurance is basically, if you go to the beginning, you start at the beginning, you have to worry about how did the injury occur. And one of the things the policies are actually also limited to is an occurrence. So if an occurrence is a specific action that has taken place, sudden, unexpected. Well, if it's on a handrail, or if it's on is that a maintenance issue? Maintenance is not covered by insurance. So upkeep and those type of things that happen over protracted or long periods of time may not fall because it's not sudden, unexpected. There's no occurrence to this. It laid on the handrail for whatever period of time. Well, then it should have been wiped up. That's not our insurance issue. That's a maintenance issue, and that's for the housing association. So there are many layers, many factors, and a ton of uncertainty that insurance companies and insurance policies are open right now. And again, particularly with homeowners associations, where these are usually smaller entity groups, neighbors bounding together, handling it themselves with reserves that are intended to fix up their units and to keep their living experience positive. Are you ready to pay an attorney to fight over a reservation of rights letter? I mean, you got good ones, but that's going to cost. It's going to be on your budget. Is it worth taking those risks at this time? My recommendation would be no. But like I said, you guys are on your boards. I would join, Bill and Bob's recommendation. Like, it wouldn't be my thing. I would be telling everyone to shut it down.
Right.
I'm not saying you can't open it eventually. I'm just saying if you were chomping at the bit to do it, I wouldn't want to be the first one. I don't want to be the test case. I want people to let's wait 14 days to see how bad it's going to be. Because Wisconsin opened up last weekend, right? I think it was last weekend, and we have a lot of people going up there. So if there's going to be a problem, we're going to see it probably in the next week or so, and you'll start to you'll start to see that come up. I mean, there's a lot of talk out there about whether there's a second wave of these things. If that second wave happens sooner, I'd rather it happen before we opened our pool, and all of a sudden the entire association has it. So, I mean, there's things you could do to protect yourselves too, even if you're going to open a pool, if you're going to make that choice for the association. I would not let a single person in your pool without a waiver being signed on behalf of that person, that they clearly, knowingly know exactly what they are doing, and that we're in a pandemic and they are willing to take that risk. And that a parent has to sign for a child to be able to be in there.
There's a water on and they can't read the signature.
If it was not signed in stock deal, I would never let someone in a pool right now.
Yeah. So just to get to that point, even with a waiver, right? Like in my practice before I started this insurance agency, like if you couldn't get by a waiver, you weren't trying hard enough. Like right. There are restrictions on how waivers can actually be applied and when there are grounds for it. They generally don't allow you to waive death, like as a rule. You may be able to sign something that says you waive it as a deterrent, but good luck actually trying to enforce it. Right. So I would just hold off on the waiver ideas.
Well, I think have something. You better have better than nothing. It is not, waivers are not very good and well enforced, especially if a child's involved. Courts hate waivers related to children. They will do their best to throw it out. So that is the most liability we're talking about. And you cannot say no children in our pools. It is prohibited under the Fair Housing Act. So you can't say that. which makes it so the waiver is not as strong. But again, if you're going to do it, at least do certain things to protect yourself, like make mandatory cleaning, make it so you know who's there and who's left. I would keep the occupancy less than 10 people if I could.
And I would just to echo what Bob's saying too, as I would extend these things to health centers within your units as well, because those are probably more likely than pools that you have a health center for your given area, making that mandatory cleanup, whether it's the person who leaves cleaning up on the behalf of themselves or whatever it might, or signing out times and having the cleanup, but having having those same processes for the interior, because gyms are under the same type of restrictions. So I would just echo these things, the great points Bob and Bill are making on those front too.
And I think to kind of sum it up for associations, here's the deal. When it comes to whether you made a bad decision or a good decision, whether being sued by a unit owner who said you should have opened it up, or by someone who claims you shouldn't have opened up and they're harmed, the one defense that as attorneys we usually like to gravitate around is business judgment. So here's your issue. If you've got a manager saying don't do it, if you've got your attorney saying don't do it, if you've got information like today, while it is not legal advice, it's a discussion on legal issues. If you've got the government agencies, if you've got the CDC, none of them saying, yeah, go ahead and do it. You've now been informed on a variety of levels with information was available to you easily, and you made a decision. When you blast past that and say, hey, thanks for the advice, but we're going to do it, you're greatly diminishing your ability to rely on the business judgment rule, which is a powerful defense. When you rely, if someone's going to be snarky enough to sue for breach of contract at the end of all this, saying, my assessments entitled me to use these facilities and you didn't let me do it, I'd rather deal with that suit than, hey, my loved one died because you opened the pool. Because the former, I'm pretty sure will be okay, because you talk to your manager, you talk to your attorneys, you made yourself aware of all the guidelines that are out there, you followed the phases, and they couldn't use the pool. Oh, by the way, they want that $20 of your assessment per month that they should have got. That's really what we're looking at, and I still think you'd be in a great position anyway, as opposed to the opposite of if some harm occurred. So
I'd always rather be fighting about money than someone's life and health.
Right.
Amen. Yep.
I'm going to interject again here because these questions are really getting numerous, and a lot of them are related. We go back to Bob, you just mentioned it, but I'm going to ask Adam, the liability word, okay? There are issues where, one question, the homeowners want to know, when are we going to set the guidelines for the common areas for walking in groups of 10? And how are we going to communicate that? And do we set rules? And is that enough to cover our liability? Who's enforcing it? We're not the association police. And if there's a group of 14, who's going to go out there and tell them to disperse? In other words, what, Adam, would you recommend for association boards to how to handle so they're covered, for liability in case something happens when these things are happening that they know are in violation of what they've communicated, are not acceptable, but how far do they have to go?
Yeah, no, that's a really great question and a really hard one to answer, to be frank. I think what's great, Betsy, about some of the information that you were able to collect is that it allows them to have some documentation posted, something public to show they're doing their diligence in trying to keep these people safe and doing their best efforts. I think it's going to be a case-by-case basis. If it's, board members are just completely flying in the face of it and ignoring it altogether, that's one thing. But if you can show a regular and a documented attempt either through emails or signs, signage, and other things, and you maintain the efforts that you're taking in order to kind of keep people informed that this is the way it's going to be, you don't have the jurisdiction to handcuff anybody or disperse a crowd really, but you do have the ability to kind of keep raising the issue and saying, hey, guys, we've had another collection of 10 plus people. And we got to think about the association members, the different unit owners. Like, we don't know how immunocompromised they may be, or whether they're an anonymous or an asymptomatic carrier, or if they're super susceptible. We don't know enough about this. And so I think it's a general respect thing, and it's a general practice thing just to keep reminding and keep stepping forward on those. And, just like you would if a noise ordinance or somebody kept, throwing big parties, you would call in and bring authorities if you needed be, but you would take those same type of tact and same type of steps to protect and keep those groups down to 10. And again, like I said, the resources Betsy pulled with the signage and the toolkits, I think are super helpful to keep people informed about it. And hopefully they'll follow through.
Right,
So
and I think you should look at
your
life.
advice would be not to just ignore it and not say anything. Just say whatever, whatever resource you can find, post it, send it, whatever, but don't just keep quiet, because a lot of associations feel like they don't want to step into the wrong, lane here or say the wrong thing, and they really can't enforce, but you
don't
communicate.
You don't have the ability to put on badges and run around being the association police. But at the same point, to reiterate and regularly inform people, look, we're following these guidelines. The state has imposed these guidelines, and take your role as a leader and saying, hey, just reminder, physically breaking up groups and stuff is not your position and your place to be. I mean, you may be able to say, hey guys, can we break it up? We're trying to keep people safe here. But at the same point I don't think there's any bright lines. I think, Bill, you were going to hop in, but I think
I was just going to say,
common sense applies.
When I open my dishwasher, there's a sign that says, don't hide inside, with a kid with a line through it. Clearly, because something, a game of hide and seek went bad years ago, and that sticker's on there. Mm-hmm. Certainly, Frigidaire, you can't do anything if it's going to happen again, other than put that sticker on there. The thing to keep in mind is, I think that within the context of the association, make sure I still prefer this to be actually published as a rule. Like, I've heard people use the word policy. I'll say, I'm sorry, I don't recognize that word. I know about declarations, bylaws, and rules. So, rules don't have to be at the first and the end of the year. Rules can come up in the middle of the year. Like I've did some meetings over the past couple of weeks, and they were very amazed that we were doing just this one rule. I'm like, well, no, it came up now. This is why we're dealing with it. So, we should say, hey, we are passing these COVID-related rules now. We're going to do X. We're going to follow the phases. We're going to ask that everyone, recognize any of the executive orders and blah, blah, blah. You do it that way. It was a properly noticed rule. They had notice and everything else. And really, we can say we did all we could. But, to Adam's point, we're not going to be able to go out there, with a flashlight and say, hey, break. I mean, you can certainly patrol it. But again, board members have their own lives as well, just like in the normal operation of the association. So.
Yeah, and I think just the last point, I mean, you are also exposing yourself to that group if you were to go out and try to disperse them. So doing it at arm's length is also proper for your own personal safety. You've got to be mindful of that. Like I said, my recommendation, using email, using rules, using other ideas that for ways to enforce it, it's going to be unfortunately necessary, because some people are taking this in varying levels of seriousness. And so you got to make sure that you're doing stuff to keep everyone safe as a board order. That's your job. That's your mission, to keep everyone safe, as opposed to just the concerns of one or two people who may be the loudest, who don't think it's a big deal.
Okay. So another question for you, Adam. If the board goes against the attorney's advice, the manager, and actually the state guidelines, does that void the D&O insurance if the board doesn't follow those?
So it depends, right? The policy language is going to really govern. The biggest issue is that violations and law exclusions. So like if you're in violation of executive orders or whatever it might be, if that resides in your D&O policy, it could be an exposure. I haven't read everyone's policies. Could it? My answer would be maybe. I would have to defer to what the form is, what the language is, what exclusions are included and what exclusions were not. That's what's going to dictate and cover the declarative action if you have, declarative action if you need to file one, or the actual coverage and provisions in the policy. So to give you your answer, I can't tell you until I would review your individual policy. But again, as Bill and Bob have said regularly, do you want to be the test case on that? Do you really want to be the one who's fighting over it? At this time, I think courts are going to be super understanding for people for sides that are conservative, and less understanding for the reckless. It's just would be my expectation based upon my time in the courthouse, as well as my term in insurance, is that they look at it from a position of action and what it was done and who did what, and who will look good in front of a jury of 12 and who will not look so good. And if you don't look good in front of 12 because you ignored everyone, and maybe somebody gets sick and dies, I wouldn't want to be in that spot. And I wouldn't want to be in that spot where an insurance carrier is trying to decide whether or not to defend that position, or do I want to get out?
Mm-hmm. Okay, I apologize. I started with the questions because I'm totally overwhelmed here between the chat and the questions. So let me go back. Adam, I kind of cut you off, and I don't think, Bob, we even got to your...
It's all right. This is good discussion.
Do you have anything else you want to cover before we go back to questions?
There's one issue I do want to make people at least aware of with regards to an issue I think that's being kind of left behind in the commercial insurance area is workers' comp. So if you as a housing association have employees, they're originally back when this first pandemic actually started, Workers' Compensation Commission came out and said that they were going to assume that any essential work staff, so if they were considered essential for your business and fell underneath that rubric, if they were required to work, they would actually have a presumption that it was from the work they were doing on your site. And so as employers or as an employer liability provision, if you don't have a workers' comp insurance, but you have employees, or if you don't have a clear independent contract status, it may be deemed employees after the fact. Just be mindful of that. That has since been rescinded, but it doesn't mean that they're not going to, in effect, do the same thing later on and to deem that the likely came from their workplace where they were exposed. And there's already cases pending against Walmart for the 2 workers that passed in Evergreen Park. There are a number of cases out there with regard to workers' compensation for people who are infected. So if your superintendents or custodial workers who are in your homeowners association do get sick, I would make sure that your workers' compensation policy is up to date or your independent contractor agreement is locked super tight and that you have employer liability potentially built in somewhere else in case the Workers' Compensation Commission deems them to be an employee. So it's really important to kind of evaluate those things as well. And then the other piece is, and I did see something about the chat of this, from a liability exposure standpoint, it's important to show process and show repeated attempts and show that it is an ongoing process. So please make sure the things that we're talking about aren't just one and done. If you're working on your process is telling everyone to be in groups of 10 and you do it for one day, and you don't do it for 30 consecutive days afterwards, including throwing parties of 30 or more in your own spaces, that's going to be really tough to defend. But if you're doing it every day and you're maintaining it and you're showing and demonstrating the way in which you're following the municipality, insurance companies likely want to go to bat for those people because they're going to want precedent that shows that it isn't related or that boards aren't responsible or that commercial businesses aren't responsible for these infections and these issues. And if you're doing the right stuff, they're going to want to fight for you. But if you're doing the wrong stuff, they're going to try and find ways to get off of it, get off that risk. And it's unfortunate. That's just how insurance works.
Sure.
Okay, Bob, do you have anything you want to say?
Just a couple things. What we were starting to see is we're starting to see courts start to open up. I actually had some teleconference court call last week. I know Bill did as well, and Rachel from our office did as well. So we're starting to see those, obviously not in the eviction cases quite yet. It's kind of up in the air of whether or not the governor is going to extend his proclamation. He has through today, technically, to do it, I believe. So if he does extend his proclamation, there's still that really, really good argument that we cannot pursue an eviction case. I know I was on a webinar with some of the judges from Winnebago, Lake, and Will counties earlier this week. Winnebago is treating it as no evictions at all. Will seems to be that they may be processing the current ones because it says you can't file them. We just can't evict anybody through the sheriff. And Lake also is opening up their cases for LMs sometime soon. So I expect to see some guidance on this from the governor's office probably today. Once again, it always seems to be the day we're doing the presentation or the webinar is the day that some proclamation is probably going to come out that may change everything we talk about in the webinar. But the good news is that we hopefully will start seeing cases in some way open up. So those litigation cases, if someone had something that they were processing, we actually can probably get into court everywhere really except Cook County. Cook County's been pushed out till after the 4th of July for basically all cases, it looks like. And the other counties are basically doing teleconferences when possible. So they specifically told us, attorneys, we do not want to see you in court. Have fun using the technology because and they don't want enough people to be there. And in some of the calls we have, there could be 100 people in the crowd in a Will County on a given day because there's so many cases. So, we're starting to see those start to open up. We'll see if we get some more guidance from the governor today about the evictions. Maybe he'll give us some guidance on pools too. That'd be great, so we can better tell our clients what to do.
And to your point about courts and collection in general, I did last week. It seems as if right now we've dodged a bullet. There was some legislation out there. It was, what was it, HB 5774? Do I have it right? Was it 74?
Yes, I think so.
So there was a proposal out there, which now looks like it has been pushed off to the veto session, the fall veto session, which it was going to pretty much put a moratorium on evictions based on a sophisticated mathematical formula about whether unemployment was within 1.5% of the February number, with 2 out of 3 previous periods of a declining trend. And it was going to do rent forgiveness, and it wasn't going to allow associations to fine. I covered that in one of our legal minutes. It's on our website. If you go to ccpchicago.com, right in the front, we've got that there, and it's also on our YouTube channel. I kind of went over it and I posted it. The upshot is, as of right now, it does not seem to be an issue. And that's when Bob was just saying a minute ago, we're kind of waiting on what Governor Pritzker is going to say today. We're kind of opining here as to whether or not he may kick it out a little bit further to kind of give a concession to those legislators who had sponsored this act, which, by the way, was heavily sponsored. It had over 20 sponsors. This was a very contentious piece of legislation because it was also going to build in their mortgage forgiveness, which, when we talked to some of the lenders that we knew, they said this was going to seize up the lending market. So there was a lot in this bill that we had to watch for. But right now, it seems to be in the governor's hands in terms of evictions and things like that. And of course, you can still, to the extent that they, again, I don't want to speculate as to what he'll do, but if he only speaks to evictions, you always have breach of contract that you could always sue for on unpaid assessment. So if they were to say, well, evictions can't happen, but they leave out collection in general, there may be a window that way. You wouldn't get possession, but you'd get a judgment. So again, rather than speculate, we'll just wait to see what Governor Pritzker says today.
I'm assuming he's going to extend it, because if he doesn't, then technically the Restore Illinois plan, there wouldn't be an ability to do it. He can only do it if he declares it a disaster, because then he's got his powers under the Emergency Management Act. So I think he has to do it. I'm intrigued to whether it will actually happen.
Yeah, I know. We'll see.
Okay, so Bob, can you just spend a couple minutes on when there's a dispute? If the homeowners don't like the decisions that are being made, and hopefully they aren't going to have signs and rioting, but what recourse do people have?
So right now what we're seeing a lot of is I've mentioned it for about a month now, is we're seeing a lot of nuisance homeowner disputes that didn't used to be there because unfortunately everybody's stuck together. And in a condo scenario, that means you're stuck together literally with walls between you, and you like music and someone else doesn't like music, or your kid jumps too much and the person below you doesn't like the kid jumping so much. That's what we're kind of facing right now. And homeowners have the ability to, petition the government, or petition the association. I almost said government. Petition the association, file complaints about actions that they think need to happen. And the board, under the dispute resolution process for the Ombudsman Act, is supposed to take that complaint, consider it, give people a chance for a hearing, and then issue a final determination. Once that's issued, the owners have their options. If they really are aggrieved, they can try to file a lawsuit against the other owner and see if they can get court to agree whether or not the other person's a nuisance. And that's a difficult burden to beat a lot of times. I'll tell you, nuisance cases are, one judge, Supreme Court justice said that it's an aberration of the law. Nobody likes it because it's not something fixed and easy to tell what it is. And it so involves facts that, a sensitive person could have it say something's a nuisance when it's not to a reasonable person. So we're seeing a lot of that. There's possibilities of using arbitration and mediation to try to resolve these types of disputes, since really it's going to be a hard press to get into court on those really quickly. If someone was going to do something, we were talking yesterday, and Adam, that there's generally no insurance coverage for if someone wants to lay a claim for mediation or arbitration, right?
So as a general, yeah, I mean, the insurance clauses occasionally, so for instance, with uninsured motorist claims or underinsured motorist claims, you'll see an arbitration clause put into there. But generally, those are first-party claims between the insurance and the insured. In this instance, because it'd be between two unit owners or that generally is not a covered loss or a covered expense under a policy.
Right. So, I mean, it just means you're going to be spending money. You're going to be spending lots of money. And unfortunately, I can say, fortunately, what we're trying to do is find alternatives right now. If someone's complaining about noise, let's find a way to try to make the noise less. If someone's complaining about smells, we try to find a way to seal off the units if we can, in order to determine how bad it is, so we can have objective evidence. Because unfortunately, when it's the person complaining, they're living through it every day, they start to seem more sensitive to it than it could be. It's something personal to them. So we have objective evidence come in of people who are not involved in the situation and say, yeah, it's really bad. Then it's something that's actionable. We're seeing a lot of problems with tenants as well, and it's unfortunate that it's difficult and I think prohibited to send an eviction notice right now unless they're in immediate danger. And I don't think having having my TV on really loud is an immediate danger. It's not nice, and it's insensitive and unreasonable, but it's probably not an immediate danger. So that's our standard right now to get into some of these courts, is in some immediate danger for an eviction. So that's going to be difficult hill to meet. But we do have avenues. As soon as we're able to, we can issue a 10-day notice to the tenants that we're terminating their lease in all types of associations, condo, common interest association, masters. So we can do that if they're violating our covenants and our rules and regulations. So that tenant who keeps having the 100-person house party, we can evict them after all this is done. You could make the argument that that's an immediate danger, is bringing 100 people to the association. But again, that's an argument you have to win in front of a court versus walking in and feeling confident you're going to win it automatically.
And to your point about people being closed together like never before, the one thing that maybe, unless you really follow enough association law, HUD put out that hostile living environment, which this is law. So if it gets to the point where it does get to something where someone's a protected class, or there's threats, harassment, not just mere annoyance, an association which is covered by HUD has to take those steps to ameliorate that situation.
And I would go further and say all associations, because all associations they fall under the Fair Housing Act, which means
right.
you have to comply. So if someone's doing something because of someone's protected class, because of their religion, their national origin, their race, that's the federal, and then the states got it so much more. I did an article one time where it just showed there's like 20 classifications in the state. There's like 7 in the federal. So the state adds things like, dishonorable discharge from the military is protected classification. Things like that. If someone's doing that because of those statistics or those classifications, the board has a duty to make it stop. You have to take action, or else you'll get yourselves in trouble.
Right. You have to be careful of that, hey, it's between the two unit owners mentality, especially when they use some of these magic words that would be covered. So, at least listen to those complaints when they come in. And if in doubt, go to your manager, go to your children's legal counsel, get an opinion on it.
Okay, back to the questions. This one's for Adam. We're going to go back to the workers' comp. Would the management and contracted workers, such as landscapers, would they be covered under the association policy for workers' comp?
Great question. So it depends. There are 3 governing bodies that can actually establish an employee-employer relationship. So it's the Department of Labor, the IRS, and the Workers' Compensation Commission. And all 3 are look back. So they don't look necessarily in advance. They won't give you an opinion or advice as to whether they are. As a general sense, if the contractor is not under your control, or isn't limited to working for your housing association, generally, if they can conduct their business in a manner, that is free and of their own devising, and a timeline of their own device. And like you obviously can set deadlines, but you can't necessarily say, all right, this is how you're going to do this is how you're going to do that. The more control you have, the more it looks like an employment. The less control you have, the more it looks like independent contractor. So as a general rule, if you're contracted with a business that does property management, it's likely that they're not an employee. If you hire an individual who's there all the time, only works for you and works 40 hours a week, more likely an employee. It's a growing scale. And unfortunately, there is no real resource for you to go and get a determination that you can then rely on later, because the specifics of the employment, especially the specifics of the injury are going to dictate it. So if they're wearing your logos, if you're scheduling their office time, if you're doing things and holding them out in ways that they would have expected to be an employee, even if you're not paying taxes on the compensation you're given, even if you're not doing those things, that stuff does not determine whether or not they're employee. Those three bodies can make that decision themselves. So a lot of times there'll actually be policy coverages you can buy in just to make sure that in the event that they're considered employees, you have coverage for that. Just understand though that like it is unfortunately a moving target, and especially with things like Uber, Lyft, and all these gig economies that are coming out, it's creating a lot more gray area for these type of things, and it's leading to a lot more precedents that are uncertain and that are varied. And so it's best to be very specific about those things, to have your agreements in line, use attorneys like Bill and Bob to make sure that those relationships are clearly stated out as, you know, contractor relationships and not employees, because that can come into play. So if there's something they sign says you are not an employee, it's not determinative, but it's part of the overall picture. So it's a way to use your attorneys to really protect yourselves.
Okay, one more for you. How often do you advise policy should be reviewed?
That's a great question. So my rule of thumb for my carrier, for my practice is 4 years or 10%. So if you've been with the same carrier for 4 years or a period of that time, it's not a bad idea to take a look. Shifting your insurance every year is there are things that will fall off. There are gaps that will be created. There are problems that will arise. If you're working with getting ahead of it and getting in advance several months before you're actually renewing is an important part of the process, so you have time to make the right the right decision, as well as for it to be a seamless transition. And so, and 10%, I mean, is if you see a difference of 10%. I will say right now in the Chicagoland area, particularly residential homeowners associations are a very difficult place to insure. Whether it's the grilling risk in your housing association, if you have grilling risks on decks, there's a lot of carriers that won't touch it because of the fire risk. Or it's the age of the building. A lot of buildings are becoming over 120 years old because they were built pre-1900. That's a major insurance risk. So those are the other things to keep in mind in that. How often is it to shave? You really have to make sure that the markets are there. It is a contracting market to find insurance carriers that will insure housing associations. And that's why it's important to work with agents who can offer multiple, because that does change. But working with an agent who, the general rule I have though is that 4-year period, because the new business, the insurance who's going to be looking at your policy for next year will want to know you've been somewhere for a period of time that's attractive to them, because they make money over the long term, not 1 year. And if they're playing hot potato with your housing association every year you're moving, they may get stuck with the massive loss and they'll only have you for that year and they're never going to make that money back. Whereas if they're with you for a longer period of time, they feel more comfortable and can make money from those years where you don't have a claim.
Okay. Legal question. I'm not going to call on either of you, whoever wants to answer. What is the difference in the definition of limited common areas and limited common elements?
Oh, so this generally only comes up. So a limited common element is generally the terminology we use for a condominium association, because we call things common elements in units in a condo. In a non-condo, we call it common area or community area generally. So a limited community or a limited common area would be a part of the common area in a non-condo that is reserved for certain buildings or parts of the neighborhood. So like we have some that are associations that are all have like driveways that are between two sets of buildings. That driveway is not part of the condos, but it's part of a community association. That driveway is a limited community area for those two sets of buildings that are on each side of it. So it's basically a way to generally push off costs and responsibility for maintenance of a common area that's outside the building and outside like a patio and such like that to the particular buildings that benefit from them. So sometimes you'll see a sidewalk being a limited common area if it walks up to a townhome unit, but more often than not, they'll just say that the association or the owner will be responsible for that sidewalk. They won't terminology it with limited common area. It's very unusual to see that. I would just recommend you talk to your attorney just to make sure that it fits what I just said. Generally, that's where it would be though.
Okay. Well, I think we've covered just about every issue. There are a couple that are, personally affect only one association, and we will hold off on those for now. So with that, I would like to say thank you very much to Adam for joining us today. We appreciate your participation. And as always, thank you, Bill, and thank you, Bob. And thank you to all of you who turned in to listen today.
Everybody have a great weekend. Stay tuned.
Yeah, stay safe, stay healthy, everybody.
Take care.